The Façade. This opinion critiques Pakistan's constitutional overhaul and the debate over constitutionalism. Recently, there has been a flurry of legislation in Pakistan. Flurry means a sudden burst of activity. This implies that many legislative measures have been introduced in quick succession. The Constitution itself has undergone a major overhaul after the passage of the 26th Amendment. Major overhaul indicates significant, sweeping changes. 26th Amendment refers to a specific constitutional change that has transformed the nation's legal framework. The changes brought in are of such great benefit to the people that their contents had to be carefully guarded until their actual passage, so that no ordinary citizen could somehow jinx the reformation being imposed. Brought in means introduced. Of such great benefit implies the changes are presented as highly advantageous. Carefully guarded suggests that the details were kept secret to avoid sabotage, jinx, by ordinary citizens, implying a top-down, paternalistic approach to reform. No one felt the need to run the proposed amendments by the people. Run by is a phrasal verb meaning to consult or get approval from. This criticizes the lack of public consultation. After all, what do the people know? Should they even have opinions on such things? Why would the people think their opinion matters? These rhetorical questions express contempt for public opinion, implying that the people are considered ignorant or irrelevant in shaping constitutional changes. There is a prefix used for civilians by those who run the show that was heard reverberating in the air above Islamabad as the 26th Amendment received assent louder even than the back-patting and chest-thumping of many politicians whose support no longer emanates from the people. Prefix used for civilians implies a dismissive term applied to ordinary people, suggesting they are inferior. Reverberating means echoing. The imagery of it being heard above Islamabad dramatizes the dismissive tone. Back-patting and chest-thumping are idioms referring to self-congratulatory, boastful behavior, indicating that politicians are congratulating themselves despite losing genuine support. It was a stark reminder, yet again, that providing services elsewhere remains more rewarding. Stark reminder emphasizes a clear, unambiguous message. Providing services elsewhere suggests that those in power find greater personal gain in other sectors, hinting at corruption or misaligned incentives. Before its passage, while the actual drafts remained concealed, there were the supposed Democrats who would invoke the doctrine of political constitutionalism at every opportunity they got. Supposed Democrats is used skeptically to question the sincerity of those claiming to be true Democrats. Doctrine of political constitutionalism is a theory asserting that elected representatives should have the final say in constitutional matters, emphasizing legislative primacy. Under this theory, the people's elected representatives ought to have a final say as to what the Constitution states and means. Ought to have a final say asserts that legislative bodies should control constitutional interpretation rather than the judiciary. It propagates the primacy of the legislature and asserts that the judiciary's review power over legislation should not exist. Primacy means superiority or first importance. This sentence contrasts the roles of the legislature and the judiciary, arguing that the latter should not interfere with legislative decisions. When the legislature says something, the judiciary, according to this theory, does not scrutinize the legislation on the touchstone of objective criteria. Scrutinize means examine carefully. Touchstone is a metaphor for a standard test. This suggests that under political constitutionalism, judicial review is rendered moot, accepting legislative decisions without question. Because the legislature said so is both a sufficient answer and an adequate justification. This phrase, in quotes, encapsulates the doctrine legislative authority is taken as self-justifying. No one felt the need to run the proposed amendments by the people. After all, what do the people know? This repetition reinforces the earlier dismissal of public input, emphasizing elitism and a disdainful attitude toward citizens. Particularly those lawyers and politicians whose parents could afford to send them to the UK for their degrees, come back as sworn converts. Sworn converts implies that these individuals have adopted the doctrine wholeheartedly. The mention of studying in the UK serves as a critique of elitism and the perceived disconnect between these professionals and the ordinary citizen. In Pakistan's context, though, There are things that can be said for this framework. This transitional sentence suggests that despite its flaws, political constitutionalism might have some merits in the local context. The judiciary's activism from Justices Saqib Nassar's and Iftikhar Chaudhry's era is a case in point. Case in point means an example that supports the argument. This acknowledges that judicial activism once served a corrective role. There have been elected prime ministers sent home unceremoniously. This indicates that some elected leaders have been abruptly removed from power, hinting at arbitrary or unjust actions. And then obviously there is the stain of judicial murder of an elected prime minister that despite efforts cannot be washed away. Stain is a metaphor for an indelible mark of disgrace. Judicial murder accuses the judiciary of causing the death or downfall of an elected prime minister, emphasizing deep institutional corruption. The argument goes that the judiciary, composed of unelected officials, is not responsive to the people, and that many within it can and in fact do tend to go rogue. This summarizes a key critique, that an unaccountable judiciary often acts independently of public interests, sometimes even abusing its power. Go rogue. The other theory is legal constitutionalism. Here the author introduces an alternative view on constitutional interpretation. The decision in Marbury v. Madison, decided by the U.S. Supreme Court in 1803, features prominently in this theory, where it has been held that the final arbiters and interpreters of the Constitution are constitutional judges. Marbury v. Madison is a landmark case establishing judicial review in the United States. Final arbiters means the ultimate decision makers, supporting the idea that judges should have the power to interpret the Constitution. There is a recognized review power where the legislation can be struck down if found to be, among other things, in violation of fundamental rights. Struck down means declared invalid. This emphasizes the protective role of the judiciary in upholding fundamental rights. Lawyers whose parents could afford to send them to the U.S. for their law degrees are often avid proponents. This implies that proponents of legal constitutionalism tend to be from elite backgrounds, further highlighting the class divide. The existence of a written constitution means that every institution, including the legislature, is subservient to the rules and principles enshrined in the Constitution. Subservient means subordinate. This asserts that all government bodies must operate within constitutional constraints. Because these rules and principles are to be interpreted and applied by the judiciary, in turn, gets an opportunity to play an instrumental role in deciding society's big issues, even if political. Instrumental role means a key, influential role. This underscores the judiciary's capacity to impact important societal debates. Provisions of the Constitution can be read down as well, which is important in Pakistan's context, because unlike the Constitution in the U.S., the Constitution here can be much more easily amended. Read down means to interpret narrowly to limit its effect. The comparison with the U.S. Constitution highlights that Pakistan's Constitution is more fluid and subject to change. There are things that can be said for legal constitutionalism in Pakistan. This acknowledges that, despite criticisms, legal constitutionalism has its defenders and potential benefits in the local context. Elections generally, even other than the ones held on February 8, 2024, are subjected to massive rigging. Massive rigging implies widespread electoral fraud, questioning the legitimacy of elected representatives. Arguably, then, Parliament all too often does not comprise people's actual representatives. This suggests that the elected body is not truly representative of the people due to manipulation and rigging. Often elected in Pakistan are self-interested capitalists for whom it is all about development funds and self-serving legislation. Self-interested capitalists implies that some elected officials are motivated primarily by personal financial gain rather than public service. In such circumstances, the judiciary must be on the lookout for the people's interest. This argues that when the legislature fails to represent the public, the judiciary should act as a safeguard for citizens' rights. Moreover, those presumed elected may have no incentive in protecting the rights of the minority and disfavored, for which again, the judges have to step in, invoking the fundamental rights enshrined in the Constitution. This reinforces the idea that the judiciary must intervene to protect vulnerable groups when elected officials neglect their duties. But this debate regarding political or legal constitutionalism is a mere facade in Pakistan, a distraction of sorts. Mere facade means that the debate is superficial. Distraction implies that it diverts attention from more important issues regarding power and governance. The political history of Pakistan has not really been about which of the two institutions has primacy under the constitution, or which institution gets to have the final say. This sentence argues that, in practice, the struggle for power in Pakistan is not a genuine contest between legislative and judicial supremacy. When the judiciary allowed the elimination of an elected prime minister, it did so not because the judges themselves needed to assert the judiciary's superiority, but at the behest of someone else. At the behest of means under someone else's orders. This implies that the judiciary acted under external pressure rather than its own volition. When the judiciary mocked and knocked down politicians, it did so, not to wave the flag of Marbury versus Madison, but because it had been asked to comply. This suggests that judicial actions were not driven by a principled commitment to judicial review, but by external demands, undermining the notion of an independent judiciary. Similarly, when the resistance has come from the judiciary, it is Parliament, the purported representatives of the people, which behind closed doors at night, envision ways to browbeat the judges into submission, responding arguably to someone else's call. Browbeat means to intimidate or coerce. This sentence alleges that Parliament, rather than upholding democratic principles, colludes with external forces to control the judiciary. The purported parliamentarians seemingly work themselves into a frenzy, remembering past horrors, the judicial murder, and the debasement of elected prime ministers, hatching schemes, ever watchful so that the prying public may not even get a whiff of the good stuff they were cooking. Work themselves into a frenzy implies they became overly agitated. Hatching schemes suggests secretive plotting. Prying public refers to an inquisitive populace, and get a whiff is an idiomatic expression meaning to catch even a small hint. In the process, many parliamentarians willingly, voluntarily, and a bit too zealously extended a hand to the same forces, at whose behest the judiciary was seen to have committed the very errors for which it now needed to be penalized. This sentence criticizes parliamentarians for colluding with the very powers that undermine democratic accountability, indicating self-interest and hypocrisy. They labeled this as parliamentary supremacy. The phrase parliamentary supremacy is used to assert that Parliament should be the ultimate authority, yet here it is portrayed as a cover for power abuse. With the 26th Amendment, Parliament may or may not have asserted itself as supreme. This ambiguity reflects uncertainty over whether the amendment truly shifted power to the legislature. The people, however, were snubbed yet again. An insult to their intelligence was packaged as something meant to convey that all had been done for their own good. Snubbed means ignored or dismissed. Insult to their intelligence suggests that the public was patronized by the process, being told that decisions were made for their benefit without genuine consultation. The writer is a lawyer based in Islamabad. The views expressed are his own and do not reflect those of his firm. Wahid at umish.edu, published in Dawn, February 21, 2025.